Thanks, Dan. So I like to say to my friends who ask me how things are going in the legal ethics world that thinking about legal ethics these days is a little bit like trying to sip of water from a fire hose. Every day something new and appalling happens that causes you to blur your memory of what happened the day before, which is rather phenomenal. I mean, just think about it. We have a president who has instructed people to defy court orders. We have an assistant to the president who has threatened to invoke the act allowing for use of military in a police role under the insurrection clause on the grounds that we are in the middle of a legal insurrection, which suggests that courts ruling against the administration are part of an insurrection rather than part of the rule of law. And just so you don't think it's all on one side or one party, we also have a former U.S. attorney here in Massachusetts who is under investigation for leaking damaging materials to hurt an opponent in the race for district attorney and then lying about it. So legal ethics issues abound, and the question is what can state bar disciplinary panels do with regards to either government lawyers or lawyers like Eastman and Giuliani, who are private lawyers but who are representing government parties. And my PR students in the room, I wouldn't accuse you of being cynical if you said, well, wait a second. Why do we have to learn rules about conflict of interests and protecting client confidences and segregating client funds when the leaders of our country are engaged in such lawless behavior? It's a little bit like Nero fiddling while Rome burns, isn't it? In fact, teaching legal ethics to me sometimes feels like Nero fiddling while Rome burns, because the rest of us have to follow rules of legal ethics or we might lose our licenses, but people in authority, up until maybe Giuliani and Eastman, have largely escaped bar discipline. So the question today is what role bar disciplinary authorities can do to protect the rule of law and rein in lawyers who might have engaged in violations of their responsibilities under the legal ethics rules. Now, those of you who have had PR remember that the preamble to the Model Rules of Professional Conduct in discussing a lawyer's responsibilities says that a lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibilities for the quality of justice. So we have obligations as lawyers to our clients, to the courts, and to the system. And the question is, what can the bar do about it when people violate their obligations to the system? Before I introduce our panel, I just want to give people who haven't had PR yet a brief primer on how the bar disciplinary system works. You remember that federal attorneys are licensed in a state. They are regulated by a state. The state can suspend their license even if the infraction appeared in federal court, even if the infraction appeared in a federal court other than the state in which they're practicing in. So federal lawyers get their authority to practice from state bars, state supreme courts. They have to do a bar exam like you all have to do. They have to pass a character and fitness test, and they are subject to bar discipline, which means that somebody can file a request for investigation against them, often a private party, sometimes a member of the media, files a request for investigation. The bar disciplinary committee of that state then decides whether to open an investigation or not open an investigation. If they think it doesn't possibly rise to the level of a violation, they can close it immediately. If they open an investigation, they conduct an investigation, and then they decide whether to issue a complaint. Once a complaint issues, formal administrative proceedings have been instituted. It goes through discovery, it goes to a hearing committee of the state board finds facts, issues conclusions of law, and then it can be appealed to the entire Board of Bar Overseers, and then the Board of Bar Overseers makes a recommendation to the state Supreme Court. That's how bar discipline works in almost every state. The question is, are federal government lawyers really threatened by this system? Are the quality of their acts inhibited by this system? Are there ways that the system can act more quickly or more proactively to prevent abuses of power by federal government lawyers? So on today's panel, we have three terrific people to talk about this subject. To my immediate left is Hal Lieberman. Hal was an assistant bar counsel here in Massachusetts for many years before he moved to New York, where he was chief bar counsel for the state of New York. Bar counsel is the counsel who basically acts as a prosecutor of a disciplinary complaint. He is also the author of New York disciplinary practice. So he's the author of the treatise on New York disciplinary practice for those of you who are going to practice in New York. He's now in private practice where he and his partners represent people who are accused of professional misconduct, and so he's defending people who are brought before the disciplinary board with a firm called Emery, Seeley, and Brickenhoff. And he is also, as we will soon learn, a legal advisor to a group called the Legal Accountability Center, which is a nonprofit that is doing work in this area. And we'll hear about some of the complaints that have been filed by the Legal Accountability Center. To Hal's immediate left is, and Hal, I should say, is a graduate of Harvard Law School. Stacy is one of our own, graduated Boston College Law School. Yay! Some of you may have met Stacy. She often comes and talks at our ethics orientation in August. I don't know if you did this year. Did you come this year? Of course you did. All right. Well, Stacy's absolutely loyal to the school. And Stacy is currently the executive director of a nonprofit called Lawyers Concerned for Lawyers, which you've probably heard or read about. And that organization is funded in part by your bar fees in Massachusetts. But prior to being the executive director of LCL, Stacy was an assistant bar counsel here in Massachusetts for many years. So she, like Hal, prosecuted bar disciplinary complaints. And Stacy, as we'll hear in a little bit, was the lead prosecutor on a case that lasted over 2 years, where she successfully prosecuted lawyers from the Attorney General's office who violated their ethical responsibilities in failing to turn over exculpatory evidence in the drug lab scandal here in Massachusetts. And those of you who aren't familiar with the drug lab scandal, there are actually two scandals. But a chemist was stealing drugs for personal use, and the question was evidence of her misuse of drugs properly disclosed to defense counsel in Massachusetts, who were representing people accused of drug crimes based on her false certificates. So those three lawyers, one was disbarred, one was suspended, and one was given a public reprimand, largely through the work of Stacy. And then to Stacy's immediate left, another Boston College Law School grad, Lauren Stiller-Rickley. Lauren is currently working as the executive director of an organization called Lawyers Defending American Democracy with my former mentor and colleague Scott Harshbarger, and they're doing really important work, which you're going to hear about today. Lauren has a long and successful career as a lawyer. She was in Big Law at Bowdoin and Dewey, a highly successful environmental lawyer after she got out of law school. And then after leaving the practice of law, she has devoted herself to a lot of public interest activities. She also has a long and distinguished career in leadership in bar associations, including president of the Boston Bar Association and a leader in the American Bar Association. So we're happy to have Lauren here to talk about the committee, Lawyers Defending American Democracy, and what exactly they're doing in this area. So I thought I'd start with a question. The rules that we're going to talk about today, for those of you who haven't had PR, I'm not going to go through all of them that might be relevant, but you remember that a lawyer can't make false statements to a tribunal. A lawyer cannot ignore an order of a tribunal or disregard an order of a tribunal. A lawyer can't make materially false statements to third parties. And my favorite catch-all, under 8.4, a lawyer cannot engage in conduct prejudicial to the administration of justice. So we're going to talk about the rules and how they can be applied to federal government lawyers and whether this is just a drop in a bucket or whether it could actually have any impact in terms of lawyers' obligations to protect and sustain the rule of law. So I want to start with a question to Stacy. You brought the largest, biggest, most notorious bar disciplinary action against prosecutors in Massachusetts. Can you say a little bit about why you think state bar disciplinary authorities have been reluctant in the past to go after government lawyers?
I think that's a trick question.
Yeah, of course it is.
The key of the trick is reluctant. And I think that it's important to appreciate that the bar discipline system has multiple parts and players. So in addition to bar counsel who investigate those complaints, as you indicated, the board, the adjudicator, has to receive and make decisions, as well as hearing committees. And so bar counsel sometimes take their cue from the adjudicators in matters. So if bar counsel has been smacked down a few times by hearing committees or the board, it may become reluctant to prosecute cases. That's just one piece. There's another piece, and I was sort of interested that the UPenn Law report, that is one of the resources we were given, sort of picked up on this idea that not all cases are visible to bar counsel, meaning that when there are motions for new trial, those happen at the trial court level. They're not reported decisions, and so unless another lawyer takes up their duty to report a matter to bar counsel has no way of knowing about it unless they have read it in the paper, which actually, incidentally, in that case, the Hamden County case, I did read in the paper that it was happening when it was happening. So that's another disadvantage. And then I think getting closer to home on bar counsel, those of us who've been around the area know that this is maybe the second or third generation of bar discipline. And that first generation of bar counsel were general practitioners. So not many of them understood or understand well criminal law, the constitutional law as it applies to criminal law, and how to prosecute well cases, particularly of failing to disclose exculpatory evidence, or even cases involving improper and inappropriate arguments, because those are really technical activities in the courtroom. And so if you have an assistant bar counsel who doesn't understand that well, they may not bring the best case and or make the best case selection. So it actually happened in this case that I had. I actually had been smacked around a little bit earlier on a failure to disclose exculpatory evidence and the distinction between the Brady Rule and the Mass Rule 3.8D. And I learned from that. In the second case that I brought, get me once, shame on you. Get me twice, shame on me. So I made sure that that didn't happen a second time. So I don't necessarily think that bar counsel are reluctant. There's a skill issue, there's a reporting issue, and then there is a bias issue in terms of adjudication and how cases are decided, but I'll stop there.
All right. Hal, do you think that there's any institutional deference going on in terms of the history of fairly light enforcement against government lawyers?
I do. first of all, it's important to point out, Mike, that there's no carve-out in the rules of professional conduct for government lawyers. They're just as liable as all other kinds of lawyers. In fact, there's two rules in particular that relate to government lawyers specifically. There's a conflicts rule for government lawyers, and there's also the rule that Stacy just alluded to, where we're talking about the two things that are blatantly unethical what government lawyers can do in the criminal context. One is to prosecute a case without probable cause, and the other is to withhold exculpatory evidence, the Brady rule, as we were discussing. So there's no carve-out. In fact, there are special obligations of government lawyers who are criminal prosecutors. But I do think that there is a reluctance to go after government lawyers if it's seen as being too political. I think there's some accusations that some of the bar complaints involve too much of a political bias. That's one factor. I think there's also a history of cooperation between bar disciplinary authorities and the criminal justice authorities, particularly, ADAs and AUSAs, who work together often if there's a criminal conviction of a lawyer or there's something else going on. So there's a reluctance to sort of trample on the relationship that has been established over the years. In New York, I can say for sure that's been the case with the Second Department lawyers, the Queens and Brooklyn Bar Council people, and the ADAs in Queens and Brooklyn in Kings County and Queens County. And then I think there are sometimes instances where there are just weak enforcement policies. Generally, bar councils just are weak sometimes, unfortunately, in certain jurisdictions. And then there's, the fear of upsetting powerful government leaders, which also plays into it. So those are all factors which can inhibit, I would say, robust prosecution of government lawyers by the bar discipline authorities. And incidentally, I would just add one thing to your introduction, which is that the federal courts also have disciplinary committees. And there is a possibility of filing a complaint involving a federal prosecutor with the federal district courts in the particular jurisdiction, which courts apply the state court rules of professional conduct, but have their own set of procedures. So in one case that I was involved in, we filed a complaint against a federal prosecutor in the Southern District of New York with the grievance committee there, not with the state court disciplinary authorities. And they don't have bar counsel. The committees in the federal courts are essentially composed of a bunch of judges and federal magistrates, and they appoint special outside counsel to prosecute these cases, but they don't have a bar counsel apparatus as the state courts do, just FYI.
Yeah, and of course, the remedy there is you can be barred from appearing in this district, but your license isn't taken away from you to practice other places.
Except for reciprocal discipline.
Right.
In reciprocal discipline, if you are disciplined in, for example, the District of Massachusetts, that discipline must be reported to the Office of the Bar Council, and the Bar Council can impose reciprocal discipline under the rules of procedure in Massachusetts. So there is this likelihood that there will be reciprocal discipline.
So, Lauren, I was wondering if you could tell us a little bit about the organization Lawyers Defending American Democracy. I know you're doing lots, but just a little bit of a capshell of what you're doing, and then describe your request for investigation against Attorney General Pam Bondi and where that stands in Florida.
Sure, thank you. I have to just say, though, in one of life's full circle moments, I was so excited when you, in your introduction to Stacy, referenced her speaking at the orientation program in August. And that program was created when I was Boston Bar President, because one of the ideas I had as president of BBA was we should make professional ethics more interesting for young lawyers so that they don't see it as this dry, what does the rules say, but do a simulation where there's a real life example and make it come to life for people. And we asked a number of the major law schools in the area if they would help us pilot this, and guess which was the only law school that agreed to do that, and you continue doing it, which is awesome. So, thank you. It was pretty fun. So Lawyers Defending American Democracy is an organization that was created in, it was actually founded, Mike referenced Scott Hirschberger, he's kind of pivotal to all this, I feel, because he gave a speech at his Harvard Law School reunion in 2018 asking the question, where are the lawyers, at a time when democracy is under assault. And at that time, it seemed to be very much under assault, and now it looks almost quaint. And at the presentation that he gave, a number of people who heard him went up to him afterwards and said, you're absolutely right, we need to do something about this. And out of that came Lawyers Defending American Democracy, which was officially incorporated in 2019. In a nutshell, what we do is we focus on the advocacy side for the most part, doing a lot of writing, calls to action, speaking, as much work as we can to help people understand what is happening at this moment and why it matters. And in that context, we have working groups now that focus on amicus briefs. We have a working group focusing on judicial independence and threats to the judiciary. We are rolling out an initiative called Meeting the Moment, where we are trying to get lawyers in every state to become involved in their communities and speaking out and helping people understand what does it mean when we talk about the rule of law, when we talk about due process, when we talk about all of these issues. So that's a very quick nutshell of a lot of work that is done largely with the support of volunteer lawyers who are all very committed and very upset about what is happening. Our accountability work is also a critical part. We feel that we kind of pioneered this. We actually did a first request for investigation. That language is not, we always called it ethics complaint, and we had a very robust discussion about whether it should actually appropriately be called request for investigation. So I was trying to make sure I use the language that you're most comfortable with. And our first one was against then Attorney General Bill Barr. It was very detailed. I was not involved in all that at that time. But the critical point of that, apropos of the earlier part of this discussion, is it was filed at before the DC disciplinary authorities, and we never heard another word ever again. So the whole sort of field, it's not really the right way to say it, but the whole way in which we're thinking about and talking about and now coming to the fore and seeing discipline happening around these kinds of cases is really starting to gel and make a difference and be far more part of the conversation. You want me to talk about Bundy now as opposed to like a process? Yeah. Okay, sure, I'm happy to. So using Bundy as an example, our most recent complaint was filed in Florida against the Attorney General, Pam Bundy, who is a member of the Florida Bar, which is why it was filed there. And I'll just give you the quick overview. It's the facts of these are complicated. What I'm always struck by in thinking about this case is that how much worse it's gotten. And I think that's important to keep in mind. Every time I look at something that happened 2 months ago, 3 months ago, 5 months ago, I'm just shocked at the speed and rate at which the abuses have continued to pile up. But in this case, as we know, when the Attorney General on her first day at work, she issued what is called her zealous advocacy memo. That's kind of what it's become known as, in which she basically admonished DOJ lawyers that their job is to vigorously defend presidential policies and actions. There was no question there about, when you are a government lawyer, your role is to represent the people. There's always a certain pride that any of us who have served in government have about our responsibilities to the public. But she made it quite clear that if a DOJ lawyer refused to appear or sign briefs, that they would be considered to be depriving the president of the benefit of his lawyers and would be subject to discipline and possible termination. So the complaint has that as the basis and uses 3 examples of early on indications of what we are seeing playing out now at a breathtaking pace. The first was a lawyer who at Ezra Ravini, who had a hearing on a TRO motion in the Kilmar Abrego Garcia case, admitted to the court that Mr. Garcia was wrongfully removed to El Salvador, that was a mistake and it should not have happened. The next day, for admitting that in open court, which was the truth and his duty to say, he was put on leave for failing to follow the directive of the zealous advocacy memo and was subsequently fired. Another example, and I'm just giving you the briefest of highlights for these cases, there's a lot more nuance around what else happened and what other collateral damage occurred at the same time. Denise Chung was ordered to open a criminal investigation into whether the Environmental Protection Agency had unlawfully awarded a clean energy project contract and was told to issue grand jury subpoenas relating to that. She looked at the file, concluded that the underlying record did not support opening a criminal investigation, and one of the higher level U.S. Attorney Ed Martin insisted that she order Citibank not to disperse funds under the contract and that she must announce that a criminal investigation was taking place. When she declined to do that, on the grounds that she lacked legal authority, the U.S. Attorney demanded her resignation. And then the third one involved the Mayor Eric Adams, who was indicted in New York for soliciting illegal campaign contributions from foreign nationals. After the election, the presidential election, Mayor Adams had reached out with his defense team to Trump's staff, subsequently to Trump himself. And then there were a series of meetings, and the result of which was that the mayor's lawyer told the president's counsel and others that he could be helpful to the administration's immigration priorities if he was not facing prosecution. So after that meeting, as a side note, by the way, Emile Beauvais, who is now sitting on a federal bench since this time, he has been put on the federal court, he admonished a prosecutor who was taking notes during this meeting and demanded that anybody who was writing any notes turn these notes into him at the end of the meeting. When Ms. Sassoon was directed to dismiss the indictment, she was then directed to dismiss the indictment without prejudice, meaning that they could hold this indictment over Mayor Adams' head through. That they could hold this indictment over the mayor's head throughout the proceedings, throughout the time in which they were looking for his support for immigration-related enforcement, and then if they were not happy with how he was cooperating, they could then just proceed with that indictment. At any rate, what she did was then write to the Attorney General. She said to the Attorney General that the agreement was negotiated without the involvement of her office, and that dropping a prosecution in exchange for a promise of assistance violated both the DOJ manual and the rules of professional conduct. And therefore, it would constitute prosecutorial misconduct. She told Bondi she could not zealously advocate for the memorandum as it conflicted with her duty of candor, and then offered to resign if Bondi would not meet with her. The result, of course, was that Beauvais then accepted a resignation. So that's the foundation.
Well, can you just very briefly tell us what you've heard back from Florida?
Oh gosh, yeah. So, in the blink of an eye, by the next day, we heard this is filed before the Florida Bar, capital T on the Florida Bar. Important to say that. And the next day, the Florida Bar said, no, we cannot investigate the Attorney General because she's a constitutional officer. And so we have no power to do that. That is an incorrect reading of that requirement. It only really, we believe, we're pretty sure we're right on this, applies to constitutional officers in the state of Florida. And we since have filed a writ of mandamus before the Florida Supreme Court, asking the Florida Supreme Court to please direct the Florida Bar to conduct the investigation that they are required to do.
Thank you. Hal, can you tell us a little bit about the work of the Legal Accountability Center and what you're doing in this area?
Sure. Very similar to Lauren's description as well. It's an organization that was originally called the 65 Project. And the 65 Project stood for the 65 cases that were brought to overturn the 2016 election, which all failed and were thrown out of court. The organization was, it's a nonprofit, bipartisan organization, I might add, that works on essentially looking for accountability for lawyers who violate the rule of law. So again, it's got its diverse aspects, but my particular involvement is as counsel to the what's now renamed as the Legal Accountability Center. The 65 Project no longer exists. And the Legal Accountability Center, among other things, is tasked with or purports to file bar complaints similar to what Lauren has described. And I'll just add one of the first complaints that we filed, my law firm filed, which is a civil rights, civil liberties boutique in New York City. By the way, I was bar counsel for the city of New York, not the state of New York.
Sorry.
That's okay. And by the way, I also wanted to say, I didn't say it, I appreciate very much this invitation. It's my first time at Boston College Law School, and I'm honored to be here. And I have many friends who are alumni of DC Law School, but I've never been into school before, so it's great to be here. And thank you for the invitation. We filed a complaint against Emile Beauvais, and we filed it in with the grievance committee of the Southern District of New York. Shortly after we filed the complaint, and we laid out the quid pro quo problem that Beauvais created by his misconduct in connection with giving Adams a break. But it might be worth pointing out that the federal judge who was overseeing the case hired outside conservative lawyer advisor on what to do under these circumstances, and the advisor came back with the proposition that the judge was really obligated now to dismiss the case with prejudice, because it would be improper to, in the advisor's and the judge's determination, to hold this over Adams' head. It was just simply too much. So the case was actually dismissed, but basically the conduct involved an illegal quid pro quo. There were other instances of Beauvais' misconduct in connection with other unrelated matters. He filed a complaint, and about a week later, he was nominated to the Third Circuit. I'm not sure that the complaint had anything to do with that, but in any event, he was rewarded for his misconduct by getting a nomination to the Third Circuit Court of Appeals. What was subsequently interesting about that was that his nomination, he had to be confirmed by the Senate, and because it's a lifetime appointment, and the Senate Judiciary Committee had a policy certainly through the years of predecessor presidents, including President Biden, that no confirmation can move forward without when there is a pending bar complaint, if it's a lawyer. And the Judiciary Committee, this was a bipartisan rule that was actually proposed by Senator Ted Cruz during the inception of the Biden administration to essentially hold up certain nominations. And I in fact represented a lawyer who was held up in the Senate Judiciary Committee because he had a bar complaint filed against him. I got the complaint dismissed. I represented the lawyer, and he went through and got this high federal position, an executive branch position. But that rule was scrapped when it came to Beauvais. They just simply ignored it. There was a bar complaint pending. They knew about it, and they simply confirmed on a straight party line vote his nomination, which went to the floor of the Senate. The Senate also knew, all the people in the Senate, Democrat and Republicans, knew that there was this significant bar complaint against Beauvais, and he was confirmed for the Third Circuit nonetheless by a straight line party vote. I think maybe 2 Republicans voted against it, but he was confirmed. So much for bar discipline justice.
So, if I may, don't take this the wrong way, but between months and months of work on LDA's behalf and the LCA's behalf in filing these complaints, you guys are 0 for 2, right?
Well, I'm still pending.
She's not done.
Okay,
We're not
well, you've got to
done.
writ a
Haven't
mandamus.
heard from.
So that leads me to the question of whether the public can be confident at all that state bar disciplinary authorities can play a valid role here.
Go ahead, you go ahead.
No, I mean, I think that's, in some respects, it's important to understand that lawyers, most lawyers, including all of us in this room, care about our reputations and care about the rule of law and don't want to be the subject of a bar discipline complaint. Whether or not it goes anywhere may, in a sense, be beside the point, in the sense that we are all officers of the court and take an oath, and we are supposed to uphold the rule of law, as Laura and Stacy have alluded to. So the value of filing a bar complaint is by putting people on notice, including the bar discipline authorities, that there's been some behavior here which should not occur. And that in and of itself is worthwhile, I think. And some of these complaints have been given short shrift, but there are others that are still pending. I've been involved in 4 or 5 other ones that I think are valid complaints. They're not frivolous. Usually these complaints are based on a judicial finding beforehand that a lawyer has engaged in serious misconduct, such as knowingly lying to a federal court, or in the case of a recent complaint against a DOJ special counsel, harassing and intimidating, attempting to intimidate and making false statements in connection with an investigation pursuant to an order of Attorney General Bondi to go get certain people who were the enemies of the president. So I think they're worthwhile, Mike, notwithstanding the fact that there may be either delayed action or no action, because it puts people on notice forever that this is what they've done and it's not correct. It's not right, and it's against the interests of the American people.
What do you think, Stacy?
Yes, of course it's worth it in the sense that, but I also think it's important forums like this and even in the filing of complaints, and I assume that the complaints that Hal and his firm are raising are made with specificity. While as an assistant bar counsel, I didn't necessarily like for a complainant or someone to tell me which rule I should prosecute or which rule the conduct violated, but I do think it is important that those complaints give facts that meet the rule. And so a lot of times, if there's something just really bad that's happened, well, that's not good enough. And so bar counsel has to be able to frame up a petition in the context of the rule, because no adjudicator is going to allow bar counsel to get away with throwing it against the wall to see if it would stick. I mean, maybe in years gone by, but now you have very sophisticated respondents counsel who litigate these things like civil and criminal litigation. They are very hotly contested. And if there is a political element to the allegation, there needs to be very specific 4-corner, 4-square. I used to say if I have to squint at it to see it, it's not going anywhere. And so those complaints need to have some specificity. And then, though, doing that gives the public at least an understanding that as a self-regulated profession, there are lawyers who care. And as those complaints improve and as bar counsel are more skilled in being able to bring those complaints, because I do agree with how that in some jurisdiction, the bar counsel just doesn't have as much resources as we do here in Massachusetts.
Can I just add one thing? Sure. There's a burden of proof. Stacy is 100% right, and I think my experience and our experience as assistant bar counsels was valuable in terms of understanding that you had to have evidence. It wasn't just allegations, it was hard evidence. So in filing these complaints now, I think it's probably true with Lauren, we focus on giving the bar counsels or grievance committees evidence to go with the complaint so that they don't have to, with limited resources that these offices have, they don't have to go out and investigate, which sometimes can be very burdensome. Either it's already admitted information or a finding by a federal court, or evidence that we can put together, like in the Giuliani complaint, where we essentially gave the New York Appellate Division, we gave all the evidence on a silver platter, and all they had to do was go to the links that we provided to find what had gone on. But that's a critical piece, is having been in the prosecutorial role, we know that the resources are limited and we have to provide hard, credible evidence. The burden of proof in Massachusetts and most places is clear and convincing evidence. The burden of proof in New York actually is lower. It's a preponderance of the evidence. But as a disciplinary counsel, we always applied the rule that you should be able to prove beyond a reasonable doubt before we would actually file formal charges. So we went by the notion that we have evidence beyond a reasonable doubt. That was just our own internal policy.
Just to add to that, for lawyers defending American democracy, it's definitely the same approach. We treat this like we would a major brief, and everything is extremely documented, and we do cite to the corresponding ethics rules, and if we're not comfortable that there's a strong case there, we don't go ahead. I think the Giuliani case is an interesting example, because there were a lot of complaints, probably hundreds, that people would have filed against Giuliani that were just, he's bad, he should be disciplined. And then there were a few, ours, yours, I think there was one other that I can think of, that were extraordinarily detailed and really did, as you said, hand up what needed to be considered. And then, when you think, and then we also did similarly with respect to John Eastman, who is now disbarred, and Jeffrey Clark and others who have been disciplined. But I just to I think bring home the point on why this matters and what we have to learn from it. So in the Appellate Division of New York, what they held in disbarring Giuliani was, and I think it's instructive to just understand these words, the seriousness of respondent's misconduct cannot be overstated. Respondent flagrantly misused his prominent positions as the personal attorney for former President Trump in his campaign, through which respondent repeatedly and intentionally made false statements, some of which were perjurious, to the federal court, state lawmakers, the public, the Attorney Grievance Committee, and this court concerning the 2020 presidential election, in which he baselessly attacked and undermined the integrity of this country's electoral process. And in so doing, respondent not only deliberately violated some of the most fundamental tenets of the legal profession, but he also actively contributed to the national strike that has followed the 2020 presidential election, for which he is unrepentant. And that is exactly the point. The impact on the country from these lawless behaviors are the point and why we have to do this work.
But yet, I'll just be devil's advocate for a second, that was, Eastman was a year ago, Giuliani was 2 years ago. Yesterday, the Department of Justice fired an FBI employee because the FBI employee wouldn't stage a perk walk for John Comey, and staged perk walks are expressly, well, not impliedly, prohibited by 3.8-, which says that a government lawyer shouldn't take any action that is designed solely to cause an undue effect on the defendant's reputation before the public. That was clearly the purpose of the perk walk, and this FBI agent was fired. So, do you think that the Trump administration is taking these complaints seriously?
So, of course not, because I think there is a level of lawless behavior that is taking place at the highest echelons right now in the Department of Justice and in the FBI, in which there is a sense of complete, I'm above reproach, you will never touch me. And so part of what we all have to do is think realistically about what does that mean. If you have a truly lawless person sitting as the Attorney General of the United States, then maybe you have to think, in addition to whatever you can do to try to bring that as an exemplar, maybe we have to think about the people who are going into court because they're afraid to lose their jobs. Heartbreaking, but they're lying. Do we just let that behavior go? Or do you have to use that as an exemplar, as a way to say, you know, this is awful. We are all in awful circumstances, but you cannot go into open court and lie to save your job.
Stacy.
I always like to get down to the lowest common denominator. So what we have is a president who, according to Ms. Bondi, is the client of the lawyers, of DOJ, and whomsoever. And at the same time, lawyers do have an obligation to guide their clients in the pursuit of their objectives. And when those objectives are unlawful, lawyers have an obligation to refrain from engaging in the unlawful conduct and or to counsel their clients to do differently. That doesn't change regardless of whether the client is the president or the head of DOJ or any other institution. I will also, though, say that Bar Council, at least in Massachusetts, and I think this is true across the country, so there is a national organization of Bar Council to which almost all of the Bar Council belong. It's a very conservative group. They are not, Bar Council in general, will not step into an ongoing matter. So if there are ongoing violations, unless you can say a lawyer is a danger to the public, and one might say Ms. Bondi is, they're not going to get involved midstream. So that's, and again, I do think Bar Council can be timid in some instances in high stakes, high profile cases. Even the case that I had, I ate a lot of Tums bringing that case. Just because you don't want to get it wrong, you don't want to be pursuing political ends, you don't want to be sort of tangling with someone's professional prospects lightly. And so I can understand why folks may sort of sit back a bit to wait for the evidence, a court, other things that, but it's clear that the administration, as the client, is not thinking about that.
Okay, let's open it up to questions. Yes, Judy.
Well, I have about 8 questions, but I'll stick with a couple, one of which is, in terms of history of Bar Council, it was earlier, 40 years ago, was seen as like a toothless tiger. It did nothing. So what I've seen over the last 40 years, it has a stronger role to play, often at the post-mortem stage, about not getting involved in current, let's wait till the case settles and that will bring Bar Council. So that question of what, but now since it actually does have a little more teeth and we're seeing it happening now, what, do you know, and do you have a sense of what defensive measures Bar Council are taking to protect themselves against? It seems ripe for capture. Let's just get a new law and let's federalize all legal ethics. Let's have a federal thing, we'll just take it away from the states. Is there concern at the bar, from your work with Bar Council, concern about that as if you guys are too successful, that you'll actually get a backlash?
Okay, I'm going to repeat the question for the people who are online. If things go as you hope and there is more discipline of government lawyers, could Congress just react by repealing the McDade Amendment and creating a separate code of ethics for federal lawyers and have them not subject to state bar discipline? Lauren?
Well, first of all, hi, my co-conspirator in that ethics work. It's so good to see you. I think that it's almost like that question always comes up for the people desperately trying to have the law be followed and trying to preserve the rule of law, to preserve the justice system. I don't think we can be thinking that way. I think we have to be laser focused on what is the challenge, what is the lawless behavior, and is there a remedy that we can help effectuate? Because the claim of weaponization is now out there to only being used against those trying to create law and order, to try to have the laws be followed. And I think that just can't be what drives us. I think if something happens and somehow people want to change the law, I guess things can continue to get worse, but it's pretty bad. And I think we all have an obligation to do whatever we can to intercede wherever we can, and this is one way to do that. And for all the students here and everywhere, I hope they take some inspiration from the fact that there are people out there who desperately care about all of this and want to try to make a difference.
Hal, what do you think about that whiplash question?
No, I agree with Lauren. I don't think it's something that you need to concentrate on. We need to concentrate on making sure that this is basically just law enforcement. It's not innovating, it's not law reform, it's law enforcement. We're just trying to enforce the rules of the road with respect to lawyer conduct. And lawyers play a big role in our society. Even the DOJ, has ethical standards which which are not dissimilar from the state law standards. And if the DOJ doesn't want to enforce its own standards, then somebody has to stand up and make it clear that they need to enforce their own ethics standards, which complement and mirror in many ways state bar disciplinary standards. But it's all about law enforcement. It's not unique and unusual. We're just trying to say that the lawyer cannot stand up in court and lie to a court, knowingly lie to a court. A lawyer cannot knowingly avoid conflicts of interest. And a lawyer can't undermine the rule of law by assisting a client, any client, in illegal or fraudulent conduct. And that's not unique. That's been there. I do think that the bar discipline system varies from state to state, and that some states are stronger than other states in terms of their enforcement, in terms of their aggressiveness with respect to enforcing the rule. Having been a member of the NOBC, National Organization Bar Council, myself for many years, I've seen Massachusetts has a very good reputation for enforcement, as does certain jurisdictions in New York. Not all the jurisdictions. New York has 4 different sets of committees and jurisdictions. It's like the balkanization of bar discipline. But there are different states with different attitudes about enforcement around the country. California is a strong state as well.
Stacy.
I just want to throw in that it's important to also understand that bar discipline is part of the judiciary. It's part of the judicial process. So talking about the separation of powers, it would be hard to imagine that at least at the state level, Supreme Courts are going to give up very easily the superintendent power that they have over lawyers. So I think at the end of the day, while I never really saw any sort of particular concern that the judiciary was going to undo, unhinge, dismantle bar discipline, at least in Massachusetts. I agree with Hal. Being in NOBC, I think Massachusetts was the best.
Okay, other questions? Yes, Bob Bloom.
As Laura indicated,
It's like, oh, don't we?
I saw that Florida bar that you guys did, it's great. Things have gotten worse. I wonder, and it's not working. Going discipline-wise doesn't seem to work. What about organizations like the ABA? What about the Mass Bar? Do what the governor of Illinois is trying to do, is to get all the bars and say, this is despicable conduct. At least the public can become aware of this despicable conduct. Anyway, as you all, I'm very frustrated.
Do you think, Bob, that high-level government actors who don't have any respect for the rule of law are going to be more motivated by a petition from the Mass Bar Association signed by 500 lawyers than they are by a disciplinary complaint?
Probably not, but I want the ABA to come out and say this is, and have a national press conference and say, what she is doing, I'm talking strictly about just yesterday,
Oh, my God.
what she is doing is not the way we as lawyers function, you know.
Well,
Laura's never gonna-
you've been involved in the ABA. Lauren, what do you think? Has the ABA played a high enough profile role here?
So, yeah, I'll get to the ABA in a half a second, but what your mention, Bob, of yesterday, shame on the media for their reporting on yesterday. You had an oversight hearing in which the Attorney General of the United States had in front of her, it was so obvious that she had in front of her a dossier that she had prepared on every single senator in that room, and when a question was asked, you, instead of looking at the questioner and trying to focus on the question, she was going through, you could tell she was looking for the tab, she was finding the pre-written whatever negative thing she could say, and instead of answering the question, she said, well, why, Senator, aren't you worried about your, whatever. It was ridiculous, but all the media reports on is fireworks. That wasn't fireworks, that was disgraceful. And it should have, we're not having the right conversations in this country at the level of which we need to have them. We're not using the right language to discuss how horrible things are with respect to what is happening. The media still insists on trying to normalize behavior that is so beyond the pale of abnormal. I don't even have words. But just real quickly on the ABA. So, LDAD had worked for a while with the ABA Center for Professional Responsibility, which is, the source of the model rules, and trying to get them to be more active in stepping up on this. That work doesn't go through the leadership of the ABA, it goes through that particular part of it. We asked for their help in getting the National Organization of Bar Council to do some training on this topic. A simple thing. They set up a meeting with some leaders from NOBC who seemed a little annoyed about it. Nothing came of it. However, back to the ABA. So an ABA friend who's been active in the ABA for a long time, former Bar Council, had an opportunity to propose a program when the Center for Professional Responsibility had their spring meeting, and proposed a program on this particular subject, complaints of public officials based on publicly available information, and invited our co-founder, Gary Ratner, to participate on that panel. That was a big thing to just get that kind of recognition in that way. And that's sort of like, okay, maybe incrementally things could happen. At the highest levels of the ABA, what we saw is certainly over the past 6, 8, 9, 10, whatever eternity it's been, a true evolution of leadership at the highest levels of the ABA through President Bill Barr's term, which ended in August, with respect to ABA statements and speaking out. The problem is, a whole different problem of those statements don't have enough reach, they gotta do more, why isn't the media picking that up? It's such a complex, nuanced set of issues that all tie in together, but they all relate to how do we get the right attention at the right time when the right thing actually happens.
And of course, the ABA is no friend of Donald Trump. I mean, Donald Trump has attacked the ABA and is trying to eliminate the ABA's role in accrediting law schools, and is trying to use the Department of Education to do that. So Donald Trump views the ABA as a threat. Mark?
Yeah, I don't want to push up with this time limit, but I certainly really bored the media coverage of pages. But more outrageous was the fact that the Democrats were completely disowned by it. I've never seen a more pathetic performance of even the great lights of this party. I think the Democratic Party has basically gone out of business. And if you look around, you see signs going out of business sale. They just don't do anything. Their fight is completely gone. And without an opposition party, we have a one-party state, and Putin and others can count well on that, and Trump is going to be equally. That's my rant.
And just to bring this around, because I think your points are really important, but to bring them around to the nonpartisan lens. The question is, how do you stand up to bullies? I mean, the country is being bullied, and we are in a situation right now where the institutional pillars of democracy are gone. We do not have separation of powers, the fundamental basis of our democracy. So how can we not say that we are not living in a time of autocracy? We do not have a functional Congress. Questions regarding what's happening at the Supreme Court. So we have to deal with, how do we have these conversations in a nonpartisan way that looks at, what does the law say, what's the Constitution say? Remember the Declaration of Independence, that anniversary is coming up. And having these conversations in a nonpartisan way, but helps educate people to understand that this isn't normal.
I was just going to say, Pam Bondi went to law school. I had heard, I don't know if this is accurate, that she flunked the bar several times. I'm not sure she was a star student. So why are the Democrats saying, hey, I heard you flunked the bar 3 times. You want to talk about me? Let's talk about you a little bit. Something like that. And the media would have picked that up.
Are there any questions from students before we adjourn? Yes.
Hi, I'm Sam. I'm just curious to talk about how we really do have sort of an authoritarian government getting more and more power. How can we empower young attorneys now to actually fulfill the mandatory reporting duty when we're up against potentially like prosecutors who, if you file a policy complaint against, there might be prosecution. How can we kind of, I guess, are you worried about if mandatory bar reporting will just be out pretty soon as we see more and more attacks on?
Hal, do you want to take that? The question is, what about the so-called snitch rule 8.3? And if we're living in a universe of bullies, are young lawyers really going to be inspired ever to report ethical misconduct?
Well, I mean, that's true before the Trump era. I mean, it's not the case that lawyers like to snitch on other lawyers, even if they have personal knowledge and the conduct is really bad. Under 8.3a, there's a requirement that lawyers and judges report lawyer misconduct. But that rule has been honored in a breach. I mean, it just, you can, for every lawyer that reports another lawyer, there are 150 lawyers that don't report other lawyers. And that's been true for a long time, for a lot of reasons, having to do with human nature, among other things. The snitch rule is called the snitch rule because it's a pejorative. But in this instance, we as lawyers can't be intimidated by what could happen to us. What could happen to us, I don't know. I mean, my firm has received a death threat and we've been hacked for defending civil rights and civil liberties. So what? So be it. It's just a matter of basically political courage. I don't see any other alternative. I mean, I think we can't control what we can't control. I can't control the fact that the media doesn't report accurately or affirmatively. I can't control the fact that Democrats are weak or anything else. I can just control what I can control, which is upholding the rule of law and upholding the integrity of the bar.
Yes, last question.
Yes, thank you for that note on having to basically be courageous in that one. I mean, I had to see that one in person with an attorney I knew who actually got her house shot at, when she was trying to basically handle a case involving violation of civil liberties. But the question that's, we've talked about how Rudy Giuliani got this far, how there's complaints against Pam Bondi. Here's the thing is, they're always just going to get a new attorney to do it whenever they lose an attorney, basically. So is there a way that state bars or the ABA compensate for that?
Sure. So the question is, if a lawyer is disbarred, won't there be another possibly unethical lawyer right behind him or her to take their place and do the client's unlawful bidding?
Where's Elliot Richardson when you need him?
Stacy, you want to take that one?
Well, I just want to piggyback up on what Hal said. You can only do what you can do, and the system is set up it's also to be a deterrent. So if somebody wants to come along and take their shot at being disbarred, well, okay, I'm sure there will be bar counsel ready to receive them.
Yeah, it is really hard in this moment to stay optimistic. But I have a job that requires me to do that, because otherwise, I'd sleep even less than I already sleep. When you have to live this stuff every minute of every day. I do believe in my heart in the fundamental goodness, righteousness of this profession. I have lived my life in situations where, as a bar leader, as a community leader, as a head of nonprofit boards, when I was in those rooms and I needed people to count on, it wasn't the doctors and the accountants and the store owners who were running to step up. 100% of the time, it was the lawyers with their time and money. So I do bar service because I believe deeply in bar service. It is a way to tap into that fundamental good stuff that we want to do, that all of us became lawyers for. And I have to believe that together as a profession, we will help get through this moment.
Well, great. Thank you all for coming today.
Thank you all. On behalf of the Rappaport Center, I just want to extend a thank you to Mike Cassidy for his excellent moderation today. Mike is the first faculty director of the Rappaport Center when he moved here to BC Law. He's continuing his service to us, and we're deeply grateful. And I also just wanted to thank Attorney Lieberman, Attorney Best, and Attorney Stiller. These are attorneys who are on the front lines and doing this work courageously each and every day. And I think that last question raised up something that I was thinking about, which is that I am glad that we have organizations like LDAD and LAC that are thinking about how to intervene as a group. I'm also glad that we have bar authorities like Stacy was and like Hal was, that are pursuing, holding us accountable as a profession to these rules. But what the last question raised is, what is our responsibilities as attorneys? I am now lucky enough to be facilitating a section of critical perspectives here, which is the first year course. And I see that many of our students were here in this room and are on the Zoom. And I think this is a moment that requires all of us to ask ourselves, what do we do? Who do we serve? Do we serve the office, the elected official who is the head of our office, the government, the people, or democracy? These are not easy questions. If they were easy, then a robot could do it. They aren't easy, which is why we need people like Hal and Stacy to be in these positions in bar counsel's offices. And I hope that these are questions that we will all keep asking ourselves, and I know that the students here at BC Law are asking themselves courageously each and every day, and will continue doing that as they become practitioners. So one of the ways in which we get to continue this conversation about what courageous lawyering means and what this moment demands is through our senior fellows. Our senior fellow who is coming on October 28th is going to be Carol Rose, who is the executive director for the ACLU of Massachusetts. And I hope that everybody online and here in person will join us when she delivers her community address. Thank you so much for coming today.